You spoke to the task force reviewing the state stand your ground law, and you laid out in black and white the way the law was passed, the kind of support that it had, and how it has been exploited in the media, which really has been a problem from the start.
It has, Jenny, because the problem was an emotional curve surrounding an emotional event. And unfortunately, we had reporters jump into a political debate, taking sides, writing and talking about things of which they had no real knowledge. They were parroting what each other said. And none of them, I assure you, bothered to look at the history of the legislation or even read the actual bill to know what it did and didn't do. And the purpose of my presentation to the governor's task force on Tuesday was to make sure that members of the task force knew the history, had a copy of the actual bill, and understood what the truth was as opposed to the parade of horribles and misleading political debate that has permeated our news for months.
And I thought when you talked about how and try to explain how this all got started, a lot of people may not even know. You said this is about jury instructions that were used to usurp the law.
Absolutely. You know, people don't realize that we have a Constitution and we have statutory law. But there are other influences that take control of our lives, and people don't know what's going on. They assume that when they get into the judicial system, that the law is being followed. But when the system starts writing its own rules or laws, then the rights of citizens suffer. Now, at one point in time in Florida history, there was a duty to retreat, and jury instructions apparently were written to conform to that. But later, sometime apparently in the 90s, when it was removed, they never bothered to take it out of the jury instructions. And so, while our Constitution didn't say you had a duty to retreat and gave you your full self-defense rights, and the statutes didn't say you had to retreat and gave you and protected your full self-defense rights, jury instructions just took them right away.
A lot of people didn't realize people were being arrested. They were being prosecuted. They had just assumed they had the right to do what they needed to do to defend themselves.
And I guarantee you there were victims sitting in courtrooms who were probably shocked to hear a judge read jury instructions and tell the jury that the fact that they were wrongfully attacked did not justify using force against the attacker, so they therefore had to find them guilty. Mm-hmm. And that's just nonsense. So the legislation put things back to where they were supposed to be. And the legislature intended and did basically three things with the bill that passed in 2005. The legislature clearly intended to protect citizens who act in self-defense. The legislature clearly intended to grant immunity to victims in self-defense cases, and the legislature clearly intended to remove the duty to retreat. And that's what that legislation did.
There's a lot of people who've been claiming, hey, look what's going on since this law passed. Justifiable homicides have risen. You addressed that too, and you said, you know what? These cases are being decided finally as they should have been in the past.
Exactly. because now that the law is passed and made it very clear, cases are being filed as justifiable homicides and aren't being prosecuted, where in the past they were listed as homicides and they were prosecuted. So the fact that the number of justifiable homicides have gone up merely means that events are being logged into the statistical system the way they should have been all along.
And I thought it was great because you really drove home that point that you have been talking about from the start of this debate. Like, what am I supposed to say? Wait a second, Mr. Criminal. Hold on a minute.
Yeah, that's it. It's like the judicial system expects victims to be mind readers and know what criminals intend to do and know what weapons they may have in their pocket. I mean, it's nonsense. When people are attacked, it's human nature to fight back. It's self-preservation. You're going to protect yourself. You're going to protect your family, your children. And to be punished because you didn't turn your back on a criminal and try to run and make yourself more vulnerable to a criminal attacker, that's just nonsense.
And you made very clear, and it's something the NRA has been talking about for years. They go after the law-abiding, but the system is really upside down. The criminals get more protection than the victims do.
Absolutely. A duty to retreat in the face of a criminal attack merely creates a safer environment for criminals to attack their victims. The very idea that it's the victim's responsibility to try to run away rather than stop a criminal from committing a violent act is patently absurd.
Yeah, and you talked about it, and you said this is not a gun bill. A lot of people want to make it that. This is all about, firearms. This had nothing to do about it. This is about self-defense.
Absolutely. There were a lot of people that made a big deal. This was an NRA bill. The NRA supported the bill. This was just another gun bill. A firearm did not appear anywhere in that bill. That bill was designed to protect self-defense rights, whether you use a knife or a gun or a baseball bat or a table lamp. It didn't say gun. It didn't say weapon. It said defend yourself. Mm-hmm. And that's what it was all about.
So, Marion, what happens now? When will the task force actually make its recommendations?
In all probability, when they meet in November in Pensacola, they will have had some draft recommendations that their staff will have drafted for them to look at, and they will probably finalize some recommendations at that next meeting in November in Pensacola. And I don't know what they anticipate doing. I would suspect that they would want the legislators who are on the task force to handle any legislation if they decide to recommend legislative changes.